not apply where that institution is acting in violation of the Constitution. It would be a very sad situation for this court to say, we will not interfere in independent institutional independence, where that institution is violating the Constitution. The petitioner's rights under Article 50, which in terms of Article 25C cannot be limited, were violated. And Article 2223 gives this honorable court power even where rights are threatened. Here they have been violated. So we ask you, with respect, to give very temporary staying the consideration of the impeachment of the resolution of the National Assembly by Senate to afford time to this honorable court to hear this petition and those weighty issues. We're not just dealing with the deputy president here. We are talking about constitutionalism. The Kenyan people in a presidential system retain the residue of Hanover. Lord, your leadership, people of Kenya elect a leader. They do not elect a semi-god. We don't want to go back to the imperial privilege. Think about the Kenyan people and about the 2 minutes.
About my good and friend, Mr. Rebuttal. So it's 2.5 minutes to you, so that I can follow Mr. Parliament.
Yes, thank you.
Yes, thank you. My lords, following what my learned senior says, and I agree entirely with him, allow me to draw your attention to the response that you'll be hearing, because that also was the summary in your brother Justice Mwita's ruling earlier today. The only basis upon which he said that conservatory orders might be suspended was the question of separation of powers. That is what will be addressed. You will be told about a case called Just Mate. You will be told about a case called Kawera Mwangaza, a more recent one in Nyeri, where the issue of separation of power was an issue. As regards Justin Mate and Mwangaza Kawera, those were cases where the orders were sought prior to debate at the county assembly. Those are not applicable to this matter. But my good and learned friend, Mr. Milimo, will be giving you a case called Mwangi Weria and two others versus Speaker Murang'a County, where at paragraphs 92 and paragraphs 93, your brother judge, the late Justice Rebuttal, also dealt with the question. Please look at the, and I say so with tremendous respect, at the issues that Justice Chacha Mwita addressed as regards substantiveness and the violations of the constitutions. Those decisions, including the Mwangi decision, are all overtaken and all did not take into account a decision by the Court of Appeal, which is more apt and which is more on all force with this case. I refer you to the case of Martin Nyaga Wambora and 3 others versus the Speaker of the Senate and 6 others. It's reported at 2014 EKLR. I am now referring to paragraph 53, the second half of paragraph 52. It is directly on this question, and this is what they say. Though the process of removal of a governor, and for these purposes we can insert their deputy president, from office is both a constitutional and a political process. The political question doctrine or separation of powers cannot operate to oust the jurisdiction vested in the High Court to interpret the Constitution or to determine the question if anything said to be done under the authority of the Constitution or of any law is consistent with or is inconsistent with or in contravention of the Constitution. And your brother judge, Justice Mwita, this afternoon, dealt at quite some length with the power, the jurisdiction of this court under Article 165 to intervene in cases where it is clear, it is manifest that the Constitution has been violated. And the only question becomes, Do we allow a two-step process where the first step is invalid on account of constitutional violations? Do we then allow that to proceed? The answer is provided in a case I've shared with my friends here, and brought the copies for the court. This is the case of Omega Enterprises Kenya Limited versus Kenya Tourist Development Corporation and two others, reported at 1998 EKLR. Those days, the paragraphs were not numbered, but I'm referring to passage at page 6. And this is what it says. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have the court declared to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. In the second paragraph, you'll find at the top of page 7, we will not read it, but where the judges there in the Court of Appeal said that anything done in violation of a court order, this is a constitutional provision, is a complete nullity, since with such a faulty foundation, the entire house of cards must collapse with much ado. Allow me to say this. In 2014, I believe it was June, July, the Honorable Justice Morgan Gogi, as she then was, stopped the Senate from deliberating on the impeachment of Governor Kivutha Kibwana. That decision is not reported. I've not been able to find it. These proceedings are being hurried the Senate, and I think sent, but the court with resources will be able to get that decision. The Senate was stopped from deliberating the impeachment of Governor Kivutha Kibwana in 2014 June. There is a precedent for what you're being asked to do. Thank you for the privilege of your attention, for your time. Thank you.
Thank you. Thank you very much. My lords, I stand to add my notice of motion dated the 30th of October, appointed by supporting affidavit, and the further affidavit, your lordships, dated.
Your motion is dated
the 30th of September. And the further affidavit, your lordship, filed before this court, dated 9th of October. Your lordship, permit me to draw your attention to paragraph 15 and paragraph 20 of my motion, which form the basis upon which Brother Justice Mugambi considered to bring this matter for the Parliament.
That is of the affidavit.
That's on the affidavit and the notice of motion. Your lordship, those are the grounds upon which we urge that this application qualifies under the case of Peter Gachagua to have made or to have gained the grounds of forming a prima facie case. Subsequent to which, your lordship, a conservatory order can ensue. Further that, your lordship, the question of public interest, your lordship, in this matter is paramount. To the extent, your lordship, the petition is seeking to look or to protect and uphold the Constitution and Article 3 of the Constitution. Your lordship, while granting the order sought, consider the paragraphs 7, 8, 9, 10, and 11, and 12 of my affidavit. And your lordship, you confirm that this is one of the applications that meet the threshold in the case of Peter Gachagua. Your lordship, permit me to associate myself with the submissions made by my esteemed friends, but also invite your lordship not to tie yourself to the traditional doctrine of separation of power as expounded by Montesquieu. Your lordship, the current constitutional dispensation in regard to separations of power has lost its virginity as it was described by Montesquieu. In the sense that, your lordship, this new constitutional dispensation has put the people at the middle of all government organs functions. And your lordship, when the people are enacting Article 10 of the Constitution, they enacted Article 10 in mind of holding organs, be it judicial organs or parliamentary organs, accountable to the people of the Republic of Kenya. And those organs are being dictated that they must observe the rule of law as and when they seek to dispense with their functions. That is to mean, Your Lordship, if Parliament failed to abide by the Constitution, then the functions or what ensues therein after is subject of interrogation and review by this Honorable Court. That is to mean, Your Lordship, that the doctrine of restraint cannot be viewed on a straight jacket. It must be viewed on case-to-case basis. That is to mean, Your Lordship, if an organ has violated the Constitution in pursuit of its functions, then this court cannot hide behind the veil of judicial restraint. Your Lordship, permit me to invite you to look at the case of the Speaker of the Senate and the Attorney General.
Just for emphasis, are you saying that the doctrine of separation of powers is no longer applicable in our constitution? That power is given to the people.
Not as described by Montesquieu.
Can you expound, please?
Your Lordship, Montesquieu speaks that these three arms of governments must operate distinctly and independently. But Article 165 of the Constitution, 3(2)d, has given you the power to interrogate the functions of any organ in this republic. That is when the separation of power lost its virginity. Your Lordship, permit me to invite you to look at the case of the Speaker of the Senate versus the Attorney General, 2013 EKR. And the Supreme Court is saying, we will state as a legal and constitutional principle that courts have the competence to pronounce on the compliance of a legislative body with the process described for the passing of a legislation. In this case, the process for the impeachment of the Deputy President of the Republic of Kenya. These courts have the competence to interrogate and even issue an order to preserve the process. Your Lordship, the courts have clauses for rights that when the court has to intervene, the court will look at the consequences of the actions being sought to be restrained. For this case, Your Lordship, if the impeachment is to be allowed to proceed, it will culminate into the violation of the Deputy President's rights under Article 38. This process have the ability to limit the rights under Article 38. Where Article 38 says that if you are elected, you have a right to hold that particular office. That is to mean, Your Lordship, that if Parliament and the Senate is to limit the rights under Article 38 of the Deputy President, the same must qualify under Article 4 of the Constitution. It must be reasonable, it must be lawful, it must be justifiable, it must be acceptable in a just and a democratic society. Finally, Your Lordship, I invite you to look at the case of Commission for the Implementation of the Constitution for the National Assembly, again 2013 PKR, and also, Your Lordship, invites you to look at the case of Martin Wambora, a matter that you asked to my senior counsel. The courts are saying that judicial restraints must not, however, be an excuse for the dereliction of constitutional duties. If the court has been empowered to conserve a particular situation so as to inhibit the violation of the Constitution and Article 258 of the Constitution, then the court cannot hold its hands to that particular constitutional duty. It's my humble submission, Your Lordship, that this is one of the keys that the court can issue conservatory orders. London is not valid. The Senate is not wasting away. Your Lordship, I urge you to uphold my motion and grant the conservatory orders as sought. But as you saw, your lordship, also look at the famous case of Margaret versus Max. Further that, your lordship, the case for Doctors for Life is also available for your consideration. That is 206. The courts are saying that as long as you have gone outside the constitutional ambit, this court can uphold the Constitution, to the rights and protect it under Article 3 of the Constitution, and most importantly, uphold the supremacy of the people. In one sense, your lordship, that was never done. And even if tomorrow, your lordship, it is going to be done in the absence of public participation. This court will take judicial notice that the Senate, as it sits tomorrow, it has not called the people of the Republic of Kenya, pursuant to Article 18 of the Constitution, to conduct public participation. There is no one who is immune from judicial scrutiny. Not the Senate, not the National Assembly, not ourselves. Your lordship, penetrate the doctrine of restraint, the judicial restraint. Let this court penetrate it. Most obliged.
Thank you. So in effect, Mr. Ndegwa, your application substantially is the same as Senior Counsel Mbute's application.
Especially only that mine is done by Mwananchi. Is asking the court to penetrate the doctrine of restraint.
Yes, right. My application is dated this is 6 of October 2024.
Counsel, Mr. Kirago Nduta, Matuta.
Yes, for the second generation. I wish to associate myself fully with the submissions by.
Sorry, Counsel, what is the date of the application?
My matter is 537.
The date of the application?
6th of October 2015. I wish to associate myself fully with the submissions which have been made by the three council schools. And the application is similar. Yes. That, my Lord, I want to submit only on one prayer, prayer number 9, that this court grants any further orders that this court deems fit in the interest of justice. I will argue only on that prayer. The facts that support this application, indeed the petition, are not controverted. The application was not replied to.
There's no response to that application.
There is no application, and it's not responsible. One of those facts is that prior to the debates in the National Assembly, the Speaker of that Assembly, as well as the Deputy Speaker, on different occasions pronounced themselves that they support the impeachment motion. Article 15 of the Constitution requires that some is entitled to fair trial, which rules that such a trial before a court or anybody must be done by a body that is impartial. Article 25, that right cannot be limited at all. Therefore, the proceedings that took place before the National Assembly fall short of Article 50 as read with Article 25. I do not wish to repeat what my learned senior, Mr. Thomas Sharia, submitted, but actions that are contrary to the constitutions are unconstitutional and therefore need to be declared null and void. So, in arguing the prayer for the appropriate remedies, Article 145 on the process of impeaching a president, which is the same process that is for impeaching a deputy president. Article 7 of Article 145 provide that, and these are the tail end of the process before the Senate. If at least 2/3 of all the members of the Senate vote to hold any impeachment charge, the president shall cease to hold office, and in this case, the deputy president, because that provision applies to that is notaries. So, in the event that the process of impeaching the deputy president goes on and he is eventually impeached, but not this court still has power to make an appropriate remedy to prevent further violation of his rights. And those are the rights that we have described in our application and our. What is that appropriate remedy? In the case of David D. and others, versus the Attorney General and others, it is 2021, EKLR. That's a BBI case. A 5-judge bench considered the question of an appropriate remedy. And that appropriate remedy is placed at Article 23 of the Constitution. That is sub-Article 3 of Article 23, where it says, in any proceeding brought under Article 22, a court may grant appropriate relief, including a declaration of rights, an injunction, a conservatory order. And in that case, the court gave the reasons, and the outcome in this case was that, fine, let the process go on. But at paragraph 44, allow me to read how the court concluded that. Accordingly, the order which commends itself to us as the appropriate relief in the circumstances to preserve the subject matter of the consolidated petitions, and which we hereby grant, is that the assent contemplated under Article The assent contemplated under Article 256 of Article 4 of the Constitution, if it were to be given to the Constitutional Amendment Bill 2020, shall not come into force until the determination of these consolidated petitions. So, if the Senate were to proceed with the impeachment motion and conclude it and confirm the impeachment, my lord, the appropriate relief would be to stay that impeachment until the consolidated petitions are heard and determined. And that is what court found in that. Yes, Judge.
So, in other words, you are telling us that you are submitting that the appropriate remedy, which found under the paragraph 9, any other remedy which this court deems fit to grant,
Yes.
is
If the orders that are sought by land friends are not granted, then you look about.
the application is your prayer is forward-looking.
Yes, we have similar prayers later.
It is forward-looking after the events.
Yes,
It considers possibilities after the event in the
Yes.
Senate.
yes,
So you are going ahead and saying in the event.
in the event, but I still associate myself with the land friends. But if it gets beyond that, look at our prayer number 9 and stop the implementation of that impeachment that may arise from those proceedings. Thank you. Yes, my team. Thank you. Thank you.
Lords and my lady, on behalf of the petitioner, my name is Simon Ndoro. I had the application dated the 2nd day from October 2024. The same is supported by the affidavit.
In which file?
My Lord, sorry for that. It's in petition 528. Application is supported by the affidavit. Application is supported by affidavit of John Mogopiago. And the gravamen of the petitioner is purely on the issue of public participation, which forms the basis upon which the National Assembly paid to follow the due process of the law, and in doing so, I submit that the National Assembly issue directions for public participation after having arrived at the decision to impeach the deputy president of this country. Thereby denying the great citizens of this country an opportunity to make decisions at the formative stage of that impeachment motion. It is not in dispute that after the impeachment motion had been tabled at the floor of the House, that is when directions to conduct public participation by the National Assembly were issued. I further submit, Lords and Lady, that directive did not provide sufficient information to the public about the decision that the representatives were taking on their behalf. This denied the citizens an opportunity for intelligent and informed responses and hindering or making the public not engage in meaningful public participation. The other issue, my lord and my lords and my lady, is that the directions to conduct public participation after tabling the motion did not give adequate time to consider the information contained in the motion. And I submit that this is the same for the time to consider the responses from the members of the public. And in so doing, the public participation report that was tabled in the floor of the National Assembly cannot be said to have been considered in arriving at a decision of impeaching the deputy president. My lord, in that submission, I'm guided by the provisions of Article 4, Article 4, Sub-Article 2 of the Constitution. And this is in respect to the provision that Kenya is a multi-party democratic state, and it's founded on national values and principles of governance as provided for under Article 10. I submit then that public participation is the lifeblood of democracy. And what was done by conducting cosmetic public participation indeed violates the very tenet of democratic states. A lot as I conclude, I think that very important aspect was overlooked by the National Assembly. It is incumbent on this court to evaluate, and as it's given the power under Article 165, to look at the actions that were undertaken by the National Assembly and find that that violation indeed allows this court to issue a conservatory order in the nature sought in the application. It cannot allow blatant violations of the Constitution by other organs to go unpunished or unchecked. Lastly, my lord, as I made in my last point, is that judicial restraint cannot be a panacea for all constitutional violations by public bodies. There has to be a limit when it is clear that the Constitution has not been followed. Thank you very much.
Thank you.
The leadership permit me to tell that this authority is a journal that they relied on. Is a journal of law published in 2015, volume 45, published by Elijah Onwatch Archer from the School of Law, Jomo Kenyatta University. It has been
You shared it. The colleague
have shared it with Mr. Milimo, equally online, and people can get it.
Thank you. Next.
The elections have highlighted the specific areas for it.
Are we through with the petitioner's side.
The interested parties. So, okay.
My Lord, on behalf of petition 250, 225, we have not submitted, my Lord. And my Lord.
What's your name?
Yes, my name is Lempa.
Proceed, please.
We are appearing together with Mr. Mwakichako Kubo.
We took program a long time ago.
Yeah, we wish to rely on our notice of motion dated and the affidavit dated the 2nd day of October 2024. And we wish to associate ourselves with the submissions of learned counsel, Mr. Mwite, senior counsel, Macharia, senior counsel, Degwa Jiro Waduta. And the gravamen of our petition.
Your petition is found in which, your application is found in which petition?
525 of 2024.
525.
Yes.
Okay.
My Lord, my lady, our notice of motion, some of the prayers that we have sought in the notice of motion have been overtaken by events because they intended to injunct the National Assembly. But that said and done, there are still orders that can accrue or can issue against the Senate. But we do not want to rehearse them, but we wish to state as follows, that under Article 23 of the Constitution of Kenya 2010, the court is mandated to make appropriate relief. That was submissions of my learned colleague, Mr. Waduta. My Lord, my lady, even where a prayer has not been sought from the court expressly, even where a party has not expressly sought a prayer, the court has jurisdiction to craft an appropriate remedy. My Lord, my lady, in the BBI case that has been quoted by Mr. Waduta, a bench of 5 judges was able to stop the president assenting to the bill to amend the constitution even after Parliament had deliberated on the bill. My Lord, the gravamen of our petition is that the disputes that are raging before the court should be kept in situ. My Lord, we have 9 consolidated petitions, and if you look at petition 525, whose petitioner is John Jomo, it has annexed another petition, which is 356 of 2024, that sought to impeach, or that seeks to impeach both President William Ruto and his deputy, Gachagua, on that one grounds that are enumerated thereunder. That particular petition is attached as our annexure number 1 in that particular petition. So therefore, my Lord, my lady, if the court is not minded to grant the orders, the conservatory orders as sought, we will be seeking that the court grants a remedy, appropriate remedy, that pending the hearing and determination of the petition, a conservatory order issue restraining the president or his agent from nominating and or forwarding the name to the National Assembly for the consideration of approval as new deputy president. On the following ground.
That's a specific prayer.
Yes.
In the application.
It is, I had, my Lord, I had submitted that even when a party has not sought an express prayer, because it is not our making that most of our prayers have been overtaken by events. So therefore, my Lord, my lady, we are beseeching the court to consider that particular prayer, which Mr. Waduta calls and which language he borrows from David Ndii case, court interference at the tail end or of a process. My Lord, my ladies, there has been submissions have been made that when one arm of the government out of the 3 is seized of the matter, the other 2 arms of the government must give that one arm of the government time to consider that particular issue in the absence of which the court's current proceedings, 9 petitions, will bring administration of justice to disrepute, my lords. My lords, do we have a prima facie case? In the case of Morao versus First African Bank Kenya Limited and 2 others, 2003 EKLI, the court says this: in civil application includes that it is not confined to genuine and arguable case. It is a case which, on the material presented before the court, a tribunal properly directing itself will conclude that there exists a right which has apparently been infringed by the opposite party as to call for the explanation or rebuttal from the latter. My lord, my lady, in the case of Naftali Ruthu Kenya versus Patrick Doita Gashure and another, the court described prima facie case by quoting Lord Diplock and American Cinnamid versus Electron Limited, 1975, when the judge stated thus: if there is no prima facie case on the point essential to entitle the plaintiff to explain of the defendant's proposed activities, that is the end of any claim to interlocutory relief. My lord, we are seeking interlocutory relief to keep all the disputes before you, 9 of them, and actually my learned senior, Mr. Nyamodi, tells the court that there are 29 of them. All those 29 disputes should be kept in situ so that the administration of justice is not brought to disrepute by having Parliament, by having Senate and Parliament moving with supersonic speed to impeach the Deputy President. My lord, as I conclude, impeaching one of the members of the presidency because the president and the deputy president are joined at the hip is not the type of soup that the respondents want to leak in a hurry. My lord, when I was growing up, I used to listen to a song by DDC Mlimani Park Orchestra that used to say, mwanetu kaza moyo uishi na mumeo, wewe mwenyewe ndio ulimchagua. So we are telling President Ruto akase moyo, akae na deputy president, yeye mwenyewe ndio alimchagua.
Can you sing that song?
My voice is not that good in singing, but I can recite the words. Mwanetu kasa roho ukae na mumeo, wewe mwenyewe ndio uliyempenda. Kwa hivyo Bwana Ruto, kasa moyo uishi na makamu wako wa rais, wewe mwenyewe ndio uliyemchagua. Asanteni sana majaji wa mahakama ya rufaa, mahakama kuu, tunaomba chonde chonde msimamishe hatima hii kwa sababu inakiuka katiba. Asanteni sana.
Thank you. Who's next?
The interested party. Do you have any interested party who is supporting those applications? Interested party is supporting those applications? Do you have one more petitioner? Because Mr. Mulimo, I don't think you are in the side of petitioners. Sit down. Who is next?
I thought there were 6.
Well, we only deal with people who are here. So then we go to the interested parties who are supporting the petitioner's applications. Do you have any?
My lords and my ladies.
Yes.
This is Mr. Mishuki appearing online for the Law Society, the second interested party.
Mr. Michuki, were you part of the LSK quorum?
Yes, we appear alongside senior counsel now. And
all right. Are you supporting the applications?
My lord, we're just clarifying the law, so I think you can guide us whether we come in at this point or at close of the respondent.
We have asked that interested parties who are supporting the applications can submit at this point in time.
Okay.
My lord, we are not supporting, so we are not entering at this time.
All right.
Lord, your leadership. We went on record in petition 509 on behalf of the Deputy President. I would like to say we are supporting the application that we have. Permit me only to add one word. This court has the discussion.
The Deputy President is now a petitioner. He cannot be a petitioner and an interested party in a consolidated petition.
509. An interested party.
We configured the parties.
Yeah, we configured the parties after the consolidation.
Leave it to the court.
All right. Then I take it that we can now proceed to the submissions from the respondents.
Yes, my lord, I have the privilege to be the first on the respondent. And my lord,
For which first respondent?
for the first respondent, my lord, needing my name. My lord, we oppose, my lord, the applications that have been cited in the consolidated petition. But my lord, before I proceed, my lord, I invite your attention to the fact that when we were scheduled to appear before you, my lord, the first order of business was that we take directions. And my lord, we presumed that we'll be taking directions, my lord, on the filings, including responses to the other petitions listed together. And therefore, my lord, we had filed a preliminary objection for the first respondent, my lord, dated the 3rd of October this year.
In which petition?
Petition E522 of 2024. And my lord, considering the nature, the directions that you gave, we will be seeking, my lord, with humility, that response be deemed as the response, my lord, to all the applications in the consolidated petitions. So say, my lord, then I'll proceed, my lord, and I'll be addressing you on only 3 points. My lord, firstly, is to invite you to the undisputed fact that there are about 29 petitions that have been filed, my lord, in respect of the subject matter before you this night. And my lord, in all those petitions, the conservatory orders that are being prosecuted before you this night, my lord, had been sought, either at the ex parte or at the inter-party stage. My lord, again, you shall note that in all those petitions, none of those orders have been granted.
Your Lordship, we might have a problem in responding to my learned friend's submissions when he refers to pleadings that are not before you. Because I reckon that your directions were that we are dealing with the files that are before your Lordship.
Yes, that is correct.
Yes, my lord, although I'm on notice of the court, unless he disputes that what I'm stating before the court, my lord, is not true.
No, Mr. Milimo, you limit that argument to the 6 petitions here.
That are before you. I thank you, Lord. My lord, I, in specific reference, my lord, to a matter, my lord, that has been quoted by the petitioners themselves, that, my lord, is petition E550 of 2024, where, my lord, the petitioner in that matter is the Deputy President himself. Lord, you shall note that there's a ruling that was delivered by your brother Justice Mwita.
In petition E550?
550, my lord, of 2024.
Yes.
But all the issues that have been raised before you this night were raised, my lord, and canvassed, my lord, exhaustively. My lord, a decision delivered this afternoon to the effect, my lord, that that application with all the issues raised was dismissed. So then that brings me to section 6 of the Civil Procedure Act. Section 7, my lord, sorry, to the Civil Procedure Act on the doctrine, my lord, of res judicata. That, my lord, by virtue of that decision of the court, this court's jurisdiction has been taken away. And my lord, my learned colleagues made heavy weather on the fact that, my lord, that was a decision by a single judge. My lord, my response to that is that a high court is a high court. And it does not matter, my lord, whether it's constituted by a single judge or more than a single judge. That is the decision, my lord, is binding on the court. And my lord, I will be referring you to the decision, my lord, of Harrison Kinyanjui versus the Attorney General, and another, my lord, 2012 EKLR. Where, my lord, in quotes, this is what your brother, and may his soul rest in peace, my lord, Majanja J, say in the quote that, my lord, the decision of a 3-judge bench is of equal force to that of a single judge exercising the same jurisdiction. Lord, that is the position before you, that the petitioners cannot run away from that decision. Lord, I was interrupted, my lord. I'm requesting that you add me, my lord, at least 3 minutes to conclude, my lord. Yes. Yes, my lord, I was going to address you, my lord, on the second point, my lord, which is that the applications that have been cited before, admittedly, my lord, by the petitioners, they have been overtaken by events. In terms of the prayers, my lord, that have been sought there, and that is all agreed, my lord, that the proceedings in the Senate commenced, my lord, on the 9th of October, and the main hearing, my lord, is due tomorrow. My lord, it's public record that, my lord, the petitioner, the lead petitioner before you, indeed filed documents yesterday. And no doubt, my lord, will be attending before the Senate tomorrow. My lord, as I wind up, impeachment, my lord, is a constitutional process. Article, my lord, 150 provides for removal of a deputy president. It's therefore, my lord, not an unconstitutional process. And my lord, having taken oath of office, the deputy president, my lord, must be ready to face the same constitution if invited to do so, as in this case under Article 140. All the points, my lord, that are being raised here, including that there's a constitutional breach, can be raised, my lord, before the Senate. None of the parties before you, my lord, is stating before you that they will be denied an opportunity, my lord, to raise all those issues. And my lord, specifically, my lord, I would be referring you to an authority, my lord, decided by your brother, Justice Onguto, my lord, in petition number 458 of 2015.
We restricted ourselves to allocating by the states.
But I was winding up, my lord, this decision. And specifically, my lord, I was referring to paragraph 92 and 93, my lord. That is
Mr. Milimo, we have agreed that you, as an African, will give you the African time because you appear in so many applications, so we'll add you 2 minutes.
I'm most grateful, my Lord, for that. I think you got. My Lord, I was referring you to paragraphs 92 and 93 of the application. My Lord, you are learned brother judge, and you saw this, my Lord. Specifically, first in a similar, my Lord, position, they state, my Lord, that the petitioner, then my Lord Mwangi area, at paragraph 93, my Lord, he said as follows: the petitioner accepted office is sought to protect and defend the Constitution. He is and is to be subjected to a constitutional process of his removal. No governor, my Lord, read deputy president should expect to avoid or shy away from a constitutional process. My Lord, this is the position point. And my Lord, we humbly urge that you do not interfere with the process, my Lord, that is ongoing. And the petitioner has already subjected himself to it, my Lord. My Lord, lastly, on the issue that has been raised about an appropriate relief, my Lord, you shall note that that is a new prayer that's being introduced from the bar. None of the parties, my Lord, before you has sought to amend the applications that have been filed before you, despite having that opportunity to do so. It's the petitioners, my Lord, who sought that we argue the applications as they are, and my Lord, it's straight law that parties are bound by their own pleadings. I humbly, my Lord, that you reject that invitation, and my Lord, determine the applications as they are. We urge, my Lord, that you dismiss those applications with process. I thank you.
Thank you.
My ladies, for the my lord and my lords and my lady, for the second respondent, in respect of the application before you in the consolidated petition or in the lead file, petition 522 of 2024, the second respondent has filed a preliminary objection dated the 3rd of this month, and it is my request that that be treated as the response to all the applications before you receive. The applications, my Lord, are opposed, and I wish to commence with the opposition to the rather offensive application that has been argued this evening in petition 522. When members of the court will retire to consider your decision in this matter, I urge you to find time to consult petition number 550 of 2024. It will be easy to find. It was a petition that is identical to this petition. The parties are the same, the issues are the same. And the relief sought both in the petition and the notice of motion is the same. The petition before you this evening was before your brother, Mr. Justice Mugambi, on the 9th of October this year. The 9th of October this year, the petitioner sought only to argue the application as to the reference to the Chief Justice for the empanelment of an expanded bench, which ruling was delivered, and that is why the Chief Justice has then referred this matter to you. On the 11th of this month, the petitioner then filed petition 522 of petition 550 of 2024. Again, seeking the same relief as is sought in this petition, and seeking in a notice of motion dated the 11th of October this year, the same relief as is sought in the application before you tonight. That application was heard by your brother, Mr. Justice Chachamuita, yesterday, and he very diligently delivered himself this afternoon. When you consult that file, the telling answer by learned senior counsel when the presiding judge of this bench asked the question, has this application been heard? And the answer was before, and the answer that was given was before a single judge, will then become apparent. This application has been heard by Mr. Justice Chachamuita. The petition seeks to have this court merely because it is comprised of more than one judge hear this matter. Members of the court, the petitioners have not demonstrated where an expanded bench of the High Court gets the ability to hear an application that has already been heard by another judge of the High Court. And I submit that there is no reason, no need to look anywhere beyond the answer that was given by counsel to the petitioner before one judge. In ordinary English, that means yes, it has been heard, but merely before one judge. My lords, my lady, there is no need for me to take too much time to submit that this court cannot sit on an appeal over a decision that has been made by a judge of congruent jurisdiction. And that point is brought out in the submissions that were made for the first petition. When it is said that other courts have favored, when the manner in which this court has applied the doctrine of judicial restraint and institutional independence in deference to the doctrine of separation of powers, that is a criticism of a decision of a judge of this court in an identical matter to this. My submission is that if the first petitioner is dissatisfied with that determination, the right thing to do is then to file an appeal as provided by Article 164, Sub-Article 3A of the Constitution of this Republic to the Court of Appeal, not to make the same application before an expanded bench. My Lord, it is my submission that agency, circumstance, or status of a party before a court does not vest the court with jurisdiction. May I request for another 2 minutes?
One.
Most of us. Agency, circumstance, status of a party before the court does not vest the court with jurisdiction. The petitioner having not been able to point to a specific part of the Constitution that allows this bench to hear a matter that has been determined by a single judge, then I submit that this court should not determine that. In respect of the other applications, in respect of the other petitions, this court in petition 550 of 2024, this court differently constituted in petition 039 of 2024 in Kiambu have decided this matter on these facts in respect of this constitutional process in a particular way. And that is that this court does not have the ability to intervene, as the petitioners have invited it to do at this time, until the constitutional process in the Senate is completed. I urge members of the court to find the same in respect of those applications and to dismiss them. And in the circumstances of the first petition, with costs. Most of it.
Thank you.
My lords and my lady. My name is Kuyoli. I am president for Respondent. Sorry, Your Worship, I think it's
Yes.
Thank you.
Thank you.
THANJI for the 3rd, the 4th, and the 7th. My Lord, we filed grounds of opposition. Respondent. Yes, my Lord. The Assembly, the Speaker, and Honorable Amason Kingi. My Lord, we filed grounds of opposition in petition E522, dated 4th of October. We pray that this be taken as a response to the consolidated application. My Lord, I want to start by pointing out that the Senate is sitting tomorrow morning to hear the matter against the first petitioner. The sitting for tomorrow was convened a week ago, and parties have already submitted documents and the evidence to be considered at the sitting tomorrow. What the first petitioner is asking you to do this evening is to issue orders that will hamstring the Senate from proceeding with that hearing. My Lord, my Lords, my Lady, I wish to rely on the decision of the Court of Appeal in Nairobi. Civil application number E093 of 2023. Awera Mwangaza versus County Assembly of Meru and Anana. My Lord, if you look at paragraph 21 of that judgment, the Court of Appeal held that they had no jurisdiction while the matter was pending before the County Assembly. Now, Mr. Mashaga will tell you that at this point, the National Assembly has concluded its process. But at paragraph 22 of that decision, the Court of Appeal proceeded to say that the Honorable Mwangaza would still have her day in court before the Senate, and if she was aggrieved, she had the right to approach the court for appropriate reliefs. That applies to the first petitioner in this matter. Senior counsel has raised the question of a right to a fair trial. There has been no trial as at today. That trial is supposed to happen tomorrow. You are now being requested to stop that trial from proceeding. In fact, Mr. Milimo has pointed out the Mwangi Wairia decision that the Senate is the trial chamber. The trial will take place tomorrow. If the first petitioner is agreed, and indeed all the other petitioners, if they are aggrieved by what will happen tomorrow, then they may approach this court for appropriate reliefs. And my Lord, the Mwangi Wairia decision is an important case because in that case, he rushed to court seeking for compulsory order, but the Senate absolved him. He was found not to be worthy of removal from office. At this point, when we do not know what the Senate will do or not do, the intervention of this court is premature. My Lord, you will also take judicial notice of what happened yesterday. The governor of Kericho had also gone to court, but when he appeared in the Senate, the matter did not proceed. It's back in office. That is why it is prudent and it is constitutional to ask that Parliament is allowed to conclude its process, and then the court can be requested to intervene. My Lord, you have been told that the first petitioner was elected by a large number of the electorate, but his conduct from the time he assumed office is a constitutional matter. The way he has handled himself, the allegations against him are made pursuant to Article 145 of the Constitution. If we follow the Gatirao Peter Munya case, it is in the public interest that the Senate is allowed to investigate those allegations, the fact, the evidence. Only after the Senate has sat and made a decision will we know whether the first petitioner is what that uncertainty will result in violations of Article 145 of the Constitution, and it is not a proper exercise of jurisdiction under Article 165. So, my lord, what the petitioner needs to do is to appear tomorrow. He has been given a chance to do so. He has not told you that they are proceeding without his participation and to present that evidence to the Senate. My lord, what the National Assembly has done or not done, allow the Senate to interrogate and make a decision on whether everything is proper, whether the threshold set in the Lombora cases has been met. My lord, if you could give me 2 minutes, or I have 3 respondents. Allow that process to be concluded tomorrow. Also allow a balance of the petitioners' private rights, the public interest and public rights. The public has the right to know if those allegations are substantial, gross, and weighty. My lord, Mr. Ndegwa told you that the first petitioner will lose his rights under Article 38. I wish to rely on the decision of the Court of Appeal in Funoi versus Judicial Service Commission that there is no right to a public office. Any public officer can be removed from office as long as the law is followed. But the law can only be followed if the process is allowed to conclude. My lord, my lords, my lady, we ask for judicial restraint at this point in time. I know some parties refer to Parliament as Parliament and the Senate. The Senate is part of Parliament under Article 93 of the Constitution. The question of public participation against Parliament must be taken as exactly that as a whole. Parliament is the National Assembly and the Senate. What the National Assembly has done, you will have an opportunity to test at the hearing of the substantive petition. The final point, my lord, is that the Senate, sitting as a quasi-judicial tribunal, it is not within the Constitution to demand that the Senate goes out to conduct public participation on whether there is gross violation of the law and the Constitution. They are required to sit, block out the noise as you want this evening, sitting as a tribunal. That is what is expected of the Senate tomorrow. Allow them to look at the document, the fact, the evidence, the witnesses, and the law. After that, the court's jurisdiction in Article 165 may be properly. For that reason, we oppose all the applications. The answer will be dismissed. Thank you, my lord.
Yes, my lord, based on the...
Sir, I believe that you are the last person on the part of the respondent.
My lord, my colleague has said that I'm not going to say a lot.
Yes. Who's the last person?
I appear for the fifth respondent, the deputy speaker.
Your name?
My name is Kuyoni.
You have not submitted?
I have not submitted yet.
That should be the one.
So you will be the last?
No. You should be the next.
Okay.
Yes, Your Lordship, in terms of protocol, parliamentary protocol, the speaker can't speak for the deputy speaker. That's why I requested my learned to come because I'm not about to say most of the...
Yes, one of you should address the court on the issue of this court. This court has been invited to second guess what would happen, and then to issue orders. Yes, one of you should address because none of you has addressed that.
No, we are going to address that issue.
Yes. Which client is Mr. Nema? Because we have had directions that where respondents have been presented previously, that he loses his rights to address it.
Yeah, that's why I asked who
is it.
And my lord, I am here to answer the question.
No. The party that is representing it.
My lord, in the configured respondents, you will see that you have the fifth respondent, the deputy speaker,
represented by my colleague, Mr. Kuyoni, who has yielded the floor to me to go first. And then, my Lord, on the sixth respondent, there is a party that I represent, that is the Speaker in person. My Lord, that is the correct position. I have every right to make submissions on behalf of the Speaker, who has been solely in these proceedings, unless my colleague.
Remember, out of your 5 minutes, you now remain with you.
No, my Lord, yeah. My Lord, I'm going to make submissions on 2 points. My Lord, one is that the matter before you has been blown out of proportion. My Lord, what you are faced with is a matter involving the simple exercise of this judicial discretion to issue conservatory orders. But first of all, it's important to mention that there are principles. Judicial discretion is like that whole melody in the donut. So there are principles that guide the exercise of this judicial discretion. And these two principles have been, the principles have been laid down in the 2 important cases I want to quote. One, the case of Mumo Matemu versus Trusted Civil Society. It's a Court of Appeal decision, my Lord. This is Civil Appeal number 290 of 2012. My Lord, determining the question of the grant of conservatory orders, you'll be applying, according to this authority, the rational basis test. The Court of Appeal is guiding you here by saying, apply the rational basis test to consider that question while respecting the doctrine of separation of powers. The doctrine of separation of powers is one of the values in the case of, it's one of the constitutional values in the case of Peter Gatirao Munya, which ought to be considered by this court when exercising that delicate balance to grant or not to grant conservatory orders. My Lord, this matter is a legitimate constitutional activity before another arm of government. Impeachment is guided in this case by the provisions of Article 150 as read with 145 of the Constitution. So, my Lord, to injunct this process, the Supreme Court has said in the second authority, my Lord, that is the authority of Justice Kariuki Mate, petition number 2 of 2014, that, my Lord, you need to exercise maximum restraint. My Lord, public participation has been conducted, and therefore the adequacy of public participation will be determined at the hearing of the main petition. But, my Lord, the mere fact that public participation has been conducted means that that remedy is not available to the petitioner to cite. My Lord, there is no other violation of the Constitution in terms of process that is so serious that will warrant you to issue conservatory orders at this stage of the proceedings. My Lord, when it comes to the consideration of the question, the petitioners stated that the respondents are rushing these impeachment proceedings. But, my Lord, the Supreme Court has again guided us on that question, that these proceedings which are time-bound, my Lord, in the Kariuki Mate case, proceedings which are time-bound, like in this case, my Lord, Article 150 of the Constitution contains timelines, my Lord, strict timelines which must be met, my Lord, for constitutional policy reasons. But these timelines, once they kick in, my Lord, you cannot then proceed to injunct that process because, my Lord, it will amount to interference with the strict timelines which have been set. And, my Lord, in the Justice Kariuki Mate case, the Supreme Court is saying that then exercise maximum restraint. There's that delicate balance of the exercise of your jurisdiction and the need to preserve a legitimate constitutional process from completing. My Lord, this constitutional process has not ended at the National Assembly. It ends at the Senate. My Lord, at the Senate, the petitioner has every right to articulate all concerns that he has about the process and about the grounds. So to that extent, my Lord, it cannot be the petitioner's case to argue that they have not been given the right to a fair trial. My Lord, the trial happens at the Senate within the confines of the provisions of Article 50 of the Constitution. My Lord, this trial starts tomorrow, and my Lord, we are praying that you dismiss the request for conservatory orders. And my Lord, on the last point, I am making my last remark on the issue of remedies. My Lord, this is a court of record. It's not a court of supposition, assumptions, and what if. My Lord, we don't know what will happen at the Senate. My Lord, you cannot issue conservatory orders as a tool for speculation. To hang it around like a cloud over a decision which is pending before a legislative arm. My Lord, that remedy cannot be fashioned in the circumstances of this case in the manner the petitioners are pleading. It can only be fashioned in cases where facts and circumstances lead credence to the grant of such a remedy. But my Lord, in this case, the process is a legitimate constitutional process. Let's not second guess the decision of the Senate. Let's not hamstring what they are going to do by issuing an order. So my Lord, I urge that you dismiss the application. The application is not merited. It's an application which my Lord, has submitted by my colleagues, amounts to a second bite of the cherry. My Lord, the High Court has already determined this application today. My Lord, today. My Lord, on the same day, another application is before another bench. So my Lord, it reflects a major question on the public policy of the judiciary. But my Lord, there is need for consistency on judicial decision making. Thank you, my Lord.
Is there a breach on that expectation?
Yes, my Lord, the public, a decision of the High Court has been issued and the people of Kenya, my Lord, have been told of the decision of the High Court with respect to the grant of conservatory orders. And my Lord, the judge has declined to issue those conservatory orders. So my Lord, the question is, what will happen? And my Lord, for good reasons. So what will happen if another bench of the High Court issues a contrary decision? My Lord, it exposes the administration of justice to public ridicule.
Mr. Wanyama, what about if this bench finds that it cannot agree with the decision rendered? Are you imputing that we must be bound by that decision simply because we are courts of concurrent jurisdiction?
But my Lord, what I'm submitting is that, my Lord, the decision of your brother Justice Mwita is persuasive to this court. But to some extent, my Lord, because the decision is based on the same facts, my Lord, on the same subject matter, my Lord, it then makes juridical sense for you when you are exercising your discretion to avoid creating a platform for inconsistency over the same subject matter, my Lord. And my Lord, that is what I'm calling judicial public policy in judicial decision making. My Lord, it exposes the administration of justice to some sort of ridicule, and my Lord, that is not good for the rule of law.
Could you be basing your argument on res judicata, maybe?
My Lord, I didn't want to go to the issue of res judicata, but I mentioned in my submission that, my Lord, the facts are the same. A decision has been made. So, my Lord, there is a legitimate expectation on the people of Kenya that that decision of the High Court will be obeyed. But, my Lord, if you reverse that decision of the High Court again on the same day, my Lord, or a day after, my Lord, it sets a dangerous precedent in the administration of justice. And, my Lord, what we are trying to submit is that we need, as judicial officers, to lay a basis for consistency in judicial decision making so that we preserve the confidence in the administration of justice in this country. Thank you.
Thank you.
Lordship Uyoni, my name is Uyoni. I appear for the field respondent, the Deputy Speaker. That's that, my lords, by saying that I do oppose the application for conservatory orders. And I associate myself, your lordship, my lady, with the submissions made by my learned seniors for the respondents. I just wish to first start by answering the question asked by your lordship on what will happen if the court does not grant the conservatory order. Your lordship, my answer to that question is that if the lordship does not grant the order, the Senate will proceed with its constitutional process and may confirm or reject the charges as presented. The situation we have before you, your lordship and my lady, is a situation that is not backed by facts. There's no life controversy. We are dealing with ifs because at this point we do not know what the Senate will decide. It may or may not confirm the charges presented against His Excellency the Deputy President. And therefore, the lordship, we submit that that is what will happen, and as has been admitted by my learned friend Mr. Kirabu, that if the Senate admits the charges as presented against His Excellency the Governor, the Deputy President, the petitions before you will not be read at negative, because as he has admitted, that this court will still have a chance to examine the entirety of the process. And they can still grant an appropriate remedy, depending on the finding that it will arrive on the process. And finally, Your Lordship, the issues raised or given or proposed in support of the motion are issues of facts. The sufficiency, Your Lordship, of public participation is an issue of facts that can only be determined upon hearing parties in the main petition. Secondly, Your Lordship and my lady, the petitioner still have a chance and another forum to present this issue. I can confirm, Your Lordship, that the Excellency the Deputy President has filed a response to the motion in the Senate. I have had a chance to look at the response, and it is one of the issues they are raising in the Senate. And therefore, there is another forum, Your Lordship and my lady, to consider the issues presented by the petitioners before you. And therefore, we pray, Your Lordship, that you will disallow that application for conservatory orders. Thank you very much.
Thank you. Yes, I would, in terms of the right to respond, I have interested parties. Yes, most of them I believe are on the screen. Okay. LFK.
Yes, my lords.
May it please you, my lady and my lords. My name is Nelson Harvey. I will submit on behalf of the second interested party, the Law Society of Kenya. My lords.
Just a minute, Mr. Harvey. We want to know the interested parties. Are you supporting the applications or opposing them? If so, then we'll begin with the interested parties opposing the motions.
My lords and my lady, we are not supporting
the motions. We'll begin with the interested parties supporting the motion.
Very well, we are not supporting.
That is you, Mr. Harvey. You are not the only interested party. Are you?
No, I'm appearing for the second interested party. So the position is that we are not supporting. So you may take whoever is supporting for now.
So what about, I think there are 3 interested parties. The first interested party was His Excellency William Samoei Ruto. The second was LSK, who are neither supporting nor opposing. That's what I get Counsel Nelson Harvey to be saying. So what about the third interested party? It was Mount Kenya jurists.
Not here. My leadership, I'm informed on that.
All right, so that means we only have LSK.
All right, we only have the LSK, and Mr. Harvey, you can proceed. I think one of you should represent LSK in these submissions.
Yes, I will speak, my Lord.
The last time you were before your brother Justice Mugambi. Counsel appearing for the LSK was one Kevin Mishu. And he had a diverse position from what my landed senior has now currently taken. That in that petition which you are referring to, that is petition 550, LSK was supporting. Yes, allow me.
Let us give counsel time to submit. Let them make their submission.
Addressed by Mr. Mishu. But we also clarify the position that they also have with the LSK, that we may not have two diverse positions.
Yes.
My lord,
My lady,
let's get this thing right. How many counsel appear for LSK in these proceedings?
My Lord, I'm leading the team for the Law Society of Kenya. My name is.
How many are you, Mr. Harvey? How many are you?
We are 4.
You're 4.
Yes.
And are you all taking a common position for LSK?
Yes, we are taking a common position.
Okay, then proceed.
my lord, maybe as the advocate on record for the LSK, I might clarify the situation. This is Mr. Mishuki. I am the advocate on record, led by Senior Counsel Nelson Harvey. With regards to this particular application, at present, the Law Society takes no position. We shall simply clarify the law with regards to the issuance of conservatory orders. On the main petition, we shall leave that to our responses.
All right, Mr. Harvey.
My Lord, ordinarily when counsel is being led, the lead counsel speaks. So it seems he wants to speak. I will leave it to him to speak.
My lord, I was simply just clarifying, since Mr. Ndego and Zero had brought up the issue of me being on record for the Law Society. Senior Counsel can proceed.
Thank you. My lady and my lords, there is no doubt whatsoever that the power to grant a conservatory order is a discretionary power. In the consideration on how to exercise that power, several questions must be interrogated by the court. My lady and my lords, the primordial question for interrogation is one of jurisdiction. At what point in time does the court have the right to intervene in impeachment proceedings? There have been several decisions, some permitting interruption and entry before the conclusion of the impeachment process, and others indicating that the court must await the outcome of the constitutional process. My lady and my lords, all these are decisions that the court may rely upon in arriving at a correct position insofar as jurisdiction is concerned for this particular case. Secondly, the court must ascertain that there is indeed a concluded violation of a right or a fundamental freedom, or a threatened infringement of that right or fundamental freedom. At this point in time, the interest of the Law Society of Kenya is to illuminate how this process is supposed to be undertaken. My lady and my lords will therefore have to examine that this matter, having left the National Assembly and on its way to the Senate, whether there has been a concluded violation of the rights and the fundamental freedoms, or are threatened violation of the rights and fundamental freedoms. Third, and which is also important, and take into account that the office of the Deputy President, just like the office of the President of the Republic of Kenya, is not a personal right, but a public issue. The court must take into account the consideration that has so far been settled so far as this matter is concerned. Public interest. What is the wider public interest? What is the ideal position that will serve the greater interest of the rest of the people of Kenya vis-a-vis the interest of the petitioner who is before you? My lady and my lords, those who have submitted before me have either indicated that this matter is res judicata or that it's not res judicata. A question was posed by Justice Anthony Mureba on whether the plea of res judicata is being raised at this particular point in time. On our part, we want to indicate that the consideration here should be one of judicial committee, irrespective of whether or not this court is bound, and it is our submission that is not bound by the decisions of judges of concurrent jurisdiction. What has to be taken into account is the principle of judicial committee. There has to be an orderly manner in which determinations are made by courts of concurrent jurisdiction. With this guidance, therefore, my lady and my lords, it is incumbent upon the court to make a consideration based on the questions that we say the court must ask itself, whether this is an appropriate case, in particular at this particular point in time, to grant a conservatory order. We believe the court will make a decision that will be in the greater interest of the people of Kenya, and so we submit.
So that I don't have to triggered by what's not in the can I play with the which means I have a lot of responsibility, but I'll try to address summarize.
How long are you seeking?
I've been given 5 minutes from 3 instructions, so that's I summarize. I'll move it.
How many counsel are responding?
I raise on behalf of the past petitioner, the Deputy President himself.
We'll also be responding in how we'll correctly responding to the 5 or 9 petition.
We'll also be responding immediately before.
We'll also on behalf of the 9th petitioner will also be responding.
Because the
because I was just going to plead that you afford us a little bit more time. We appear for the Deputy President, who is the subject matter of the impeachment. I will not be
the truth.
He responded yet.
I think the rest of the parties will not give you more than 3 minutes. Mr. Trump will give you 8 minutes. Senior counsel will give you 8 minutes.
No, I will only responding.
Okay.
We have just pleading.
We'll give you 8 minutes.
Yes.
But the others must be.
Your Lordship, the court, unless it wants to negate its position, is that we have 5 minutes of response. Perhaps you need to reconsider directions.
But
it would be very unfair, Your Lordship, for the court to shift the goalpost at the time when we are about to score.
For us,
okay.
Whatever response he gives, which I intended to give, I'll just appreciate myself.
8555. Most of that are not. My last colleagues began by asking what is the magic of 3 judges as opposed to 1. You are read for a decision of the High Court, and you are told 3 judges are equal to 1 judge. That is not correct. Since our Constitution in 2010, the subject of judges of an even number, being not less than 3, is a constitutional matter. Article 165, sub-article 4, states that any matter certified by the court as raising a substantial question of law, under clause 3b or d, the Constitution, article 165, shall be heard by an uneven number of judges, being not less than 3, assigned by the Chief Justice. Your authority is drawn directly from the Constitution of Kenya, and it is stated that amongst the criteria that must be met when determining whether to grant a 3-judge bench is the question of of the substantial question of law. But when Justice Mugambi sat on this question of whether this matter met the criteria established by Article 165, sub-article 4, amongst the decisions he cited is a case called Philomena Mwilu versus the DPP. I think I can cite it off and what he said. What he said was, amongst the questions that render a matter of substantial importance is the question of different interpretation of the same question of law. That is what confronts you today. That is the magic that you have to grant the orders you've been asked for today. My other friends have then told you that the matter is sub judice, and they've asked you. And before I go to that, part of the magic, so to speak, that a 3-judge bench brings, for example, my Lord Justice Rima has had occasion to interrogate at great length the questions here, the political question doctrine, the constitutional avoidance doctrine. There's a case called Anthony Miano and others versus Attorney General and others. And it's cited for the benefit of my colleagues in 2021 EKLR report, Anthony Miano versus AG. And at section 102, your Lordship cited a case called William Odhiambo Ramogi and 2 others versus the Attorney General, and this is what he said. There are constitutional, and you're discussing here the exceptions to the separation of powers doctrine. This is what he said. You're citing a case that subsequently went to the Court of Appeal and was upheld. There are constitutionally permissible situations where this court will interfere in the policy decisions of the government, and particularly if a policy decision is in actual or threatened violation of the fundamental rights guaranteed under the Constitution.
My Lord, now that my good and learned friend Mr. Macharia is introducing new materials in the joinder, I trust we will have an opportunity to respond to them.
I was just reading the law as declared by the Lord Justice Rema. And the necessity of indicating constitutionally secured personal liberties and fundamental freedoms is the principal justification for the anti-majoritarian power that judicial review confers upon the courts. And we are there reluctant to find that a claim of fundamental rights, such as the one presented by the petitioner, is non-justiciable, even though it may concern political process. That's what was happening there. It was a political process. And the courts have on that occasion been thrown out the same arguments. You must restrain yourself. I think the word is today is maximum restraint. But there are exceptions to this doctrine. Among the doctrines, and you'll find that in the ruling that Justice Muta delivered today, is immediate threat to violation of the Constitution, immediate threat to the violation of rights. Now, you've been told about sub judice, you've been told about res judicata, as I've explained. You are not sitting in the place of a single judge. You have constitutional authority under Article 164 to review that matter. That's number one. Number two, as you will find when you retire to write your ruling, Justice Muta dismissed the very question. Sub judice. It was raised before him. He was told that there is this matter, and that he should not therefore hear that one. He dismissed that issue. You have been told that you must, again, as I said, recuse yourself, restrain yourselves. As I've said, that's not universal. We have a case of Kibuza Kibwana, as I've said, going back to 2014, in June or July. My learned friend, Stanji, said that, I think cited before the cases I told you, this is Mwangaza and Mwangi area. I think as I've demonstrated from the Wangora case, it is not correct that an unconstitutional process cannot be interfered with, even midstream, and for good reason. If I did put the knowledge that my good friend Mr. Ndego here talks about football, what you're being told as the referees, as the guardians of our constitution, is that you must watch as fouls are made on players, you must watch as the ball is thrown out, and all you can do is register something, so that at the end of the game, you will now declare who won based on the fouls and everything else that happened before. If a player needs to be red carded in the middle of the game, he is the National Assembly needs a red card. They have violated the Constitution. They have not conducted public participation. We set out a number of things they have not done. And so you cannot be told that you must wait until the patient is dead, until the prisoner has been hanged. Then we can examine whether he was hanged correctly. You have been told that we must wait for the Senate because the Senate has exclusive jurisdiction of this matter. We don't know what the Senate will or will not do. We've been told the Senate needs to investigate this matter. The Senate has been told it's a political process. They do not, and I think one of the responses they saw here, you were told the Senate votes. A vote is a number, it's like an election. You have faceless voters, 1, 2, 3, 4, page 1, 2. It's that simple. That's what it is. So, and one of the decisions I've seen says this is not akin to a criminal trial. This is a political process. And so, and Justice Mugambi, I think, noted in his ruling, and you'll see that it's the first time it's happening in Kenya. We do not have a template for how this is done. He also said we need to get this right. We cannot be saying that, yes, we accept National Assembly may have done some wrong things. We even know the Senate, for example, I think they said before Justice Munsa, will not be conducting public participation because, as they say, Article 118 talks about Parliament, not the Senate. That's what Uzalendo has just said. But the decisions rendered by this court say each of the two bodies with distinct roles under the Constitution must do their own public participation. There's a court order on this issue. So we cannot be told, wait until we've hanged this man, and then we'll determine whether he was hanged with the correct rope. That is not acceptable. And other issues, for example, if the motion, for example, that was determined by Parliament was defective, just like a charge sheet, do you proceed with a criminal charge, a criminal case, when the charge sheet is incurably and constitutionally defective? My sheet band, they have been triggered. We've been told that, let me just say one or two things about what my good and learned friend Mr. Wanyama said. He told me that the matter is being blown out of proportion. This is a normal matter. The judges have said it's not a normal matter. You will see the rulings on this question. You've been told about timelines. Then the National Assembly and the Senate have constituted their own timelines. Again, I say my client has been accused of saying Usiguse Murima. They have come and told him Usiguse Senate. Please, I urge you, Guse the Senate. I conclude in asking you to do this with the words of the Court of Appeal in the Martin Ondora case versus Speaker of the Senate, paragraph 59. I'm closing with this. The supervisory jurisdiction of the High Court, as well as the court's jurisdiction to interpret the Constitution, ensures that a governor, and in this case the deputy president, cannot be removed from office if the constitutional procedure has not been followed and the constitutional threshold established and proved. We find that the difference in procedure and grounds for the removal of the president, governor, or member of the county assembly does not vitiate the constitutional process and threshold that must be fulfilled for each of the distinctive offices. We urge you to grant this order. If indeed you do, and if indeed the petitions are rendered dismissed, we will proceed from where you suspended the matter. That is announcement, there will be no prejudice to the Senate, the National Assembly. It may very well be that a Parliament or National Assembly is convened on Friday, so I alluded to just with a vote on that. Monday next week is a public holiday. We have 3 days. And the last time the Senate concluded its operations and they impeached our client.
Objection, that's a new matter.
Sure.
Yeah, governed by the Constitution.
All I'm saying that the prejudice and the proportionality, the balance convenience lies in favor.
I want to just clarify something that you said. Allow me to take you back a little bit.
Yes.
The magic about the 3 judges versus the 1 judge.
Yes.
3-judge bench draws its authority from Article 165.
Yes.
Where does a single judge draw their authority from? Is it not from the same constitution? And so are you by any chance submitting that one is superior to the other, or?
And what I'm saying, a single judge draws the authority like every other judge from, in this particular case, 165.03. But in their wisdom, the people of Kenya felt there are certain substantial questions. That was the difference. That's what they call it, substantial questions. That must be dealt with by more than 1 judge. It didn't in the Constitution. This will be in the High Court Practice and Procedure Act. It is in the Constitution, the foundational document. There must be a reason we did this. And when you read Justice Mugambi's decision, he explains why with the help of 3 decisions, including one of the Philomena Mwilu versus the APP. Thank you very much for the privilege of your attention, for your time.
Thank you.
Thank you, Your Lordship. Perhaps just to give from questions posed to us by the Justice, I consider this to be a 2-tier process. A single judge and a subsequent tier of a bench, in the sense that the bench is constituted to deal with an issue that is novel. Permit me, Your Lordship, to just respond to a few issues. There was a comparison that was drawn by my learned friend, Ms. Lanji, that it is no right to hold a public office, and she cited the case of Justice Tunoy. The difference between that case and our case, Your Lordship, is that our clients holds this office pursuant to Article 38 of the Constitution, which provides that, Your Lordship, that every citizen is free to make political choices, which includes the right to be a candidate, that is clause 3, paragraph C, to be a candidate for public office or office within a public political party of which the citizen is a member and elected to hold that office. That's the distinction between the case for Justice Tunoy and the case for the past petitioner. That if he's elected, he has the right to hold that office. And if that right is to be limited, Your Lordship, then the same must be limited in accordance to Article 24. That is then, Your Lordship, that you must then interrogate the provisions of Article 24. Have that limitation passed the test of Article 24 when we are saying that the Parliament has contravened the same Constitution? Does it pass the test posed by Article 24? That is, Your Lordship, our answer to that is, Your Lordship, that the same does not pass that test. Your Lordship, you have been told that there is constitutional timelines under Article 150. There is nothing misleading as such. Because Article 150 does not provide for any timeline. The timelines are provided for in the standing orders, which will challenge their constitutionality or failure to comply with the same Constitution. And therefore, Your Lordship, the question therefore that deserves an answer, is, can you violate the Constitution, then create on constitutional timelines or timelines that have been provided for by statutes or subsequent legislations? If you want to claim that there must be strict adherence to the timelines, then you yourself, who is craving adherence, must be able to conform to the provisions of the Constitution. And therefore, Your Lordship, it's our submission that fair trial and account for faith, it has been argued by the first petitioner will receive fair trial and at 50 and there's no chances of it being violated. But where is this fair trial predicated? We are saying that, Your Ladyship, that the foundation upon which this fair trial is predicated is contaminated and tainted with constitutional illegality that are sticking to the high end. Therefore, Your Ladyship, I join issues with the submissions by my learned friend, Mr. Mashari, that garbage in, garbage out. There is nothing good that can come out from an illegality, a process that has been constituted on an illegality is an illegality to the end. And the court cannot watch and perpetuate that illegality so that then you're told that judicial restraints invites you to just hold and fold your arms. As I sum up, Your Ladyship, permit me to refer you to the same journal. And I refer you to the finding by Jacob J, who is a judge of in Trinidad and Tobago. In the case of Trinidad and Tobago Civil Rights Association versus the Attorney General, this is what the court said. The court said that courts should, as far as possible, avoid interference with the pre-enactment legislative process, but also added that the test to be formulated is whether it has been shown that if a bill is enacted, an applicant will not be able to access relief because the bill's objects would have been achieved. The courts nevertheless asserted that if the bill in question were enacted, the courts would have the power to declare unconstitutional. Leadership, you're being invited by this authority to look at what is the possible consequence of this impeachment. The possible outcome is that the first petitioner will cease to hold office upon voting. Finally, Your Lordship, Ms. Dante has invited you to look at the Senate as a very solemn and sacred and sacrosanct place. She has not told you that upon the presentation of the cases, the Senate, who are supposed to sit as a jury, will debate and persuade each other to change perhaps their position. So, Your Ladyship, after being told that the Senate is a very solemn house where silence will be observed as the case is being adjudicated, she has not told you that it's a house of debate, that the decision that shall be made shall be pursuant to a debate that shall culminate into a voting. Finally, Your Ladyship, look again at the case of Doctors for Life. You have been told, Your Ladyship, there is nobody who is again beyond your statement. Your Ladyship, I think you have all these applications and find that the impeachment is predicated on a stinking illegality. Let the court not fold its arms and hide behind the veil of judicial scrutiny instead of leadership. So the judicial respect.
Your Lordship, Honorable Aduta, as we sit here today, my Lord's Lady, the outcome of the petitions that are before you are so significant that you will set a precedent on impeachment in emerging and modern democracies. We have not had any matter such as the one that is before you today on impeachment of presidents or a deputy president in a democracy like ours. Lord, the conservative order that I highlighted earlier, which is at the appropriate list under Article 23, is based on this very practical situation. In the event that the Senate proceeds to impeach the deputy president, what follows thereafter immediately is that he ceases to hold that office. Then, within 14 days, which can even be 8 hours, the president nominates a deputy president nominee. In 60 days, which again can be 1 day, the National Assembly approves that nominee, and thereafter that nominee is sworn in and becomes the deputy president. If you do not issue a conservatory order, and at the end of these petitions, it is found that the impeachment was unconstitutional and wrong, we will already have another deputy president. Lord, there is no provision in the Constitution or the law for the wrongly impeached deputy president to reassume the office. On the other hand, there is no provision for removal of the newly appointed deputy president upon a finding that the previous deputy president was wrongly impeached.
My Lord, with respect to the new issues,
I'm just demonstrating a practical example, so that you will create a situation whereby we more or less have 2 deputy presidents. And the only way to prevent that is to prevent nomination and assumption of office by another deputy president before you determine the appropriateness of these impeachment proceedings. The appropriate relief would be then to put a stop at that time, because the moment impeachment is confirmed by the Senate, we will not have an opportunity to ventilate these issues before another person takes office.
Mr. Watut, when you are drafting your application,
yes,
you knew of that possibility.
Yes.
Did you put in a substantive prayer on that?
Prayer number 9 covers that situation. Any further orders that this honorable court is in the interest of justice. That's the prayer number. And my Lord,
what you're submitting on is not the same as how the prayer say. Like, I'm asking whether you put exactly what you're saying as part of your application.
It is not in the application.
Okay, thank you. Thank you.
My Lord, in the revision which I had cited earlier, that is the ABI case, DAP, and others versus Attorney General, at paragraph 3, the court has repeated the prayers which have been sought in that application that was being determined. And my Lord, what you will learn is that there was no prayer for appropriate remedy or appropriate relief. The only prayer that was there was prayer number 3, which was any other relief that this honorable court deems fit to grant.
And is there a possibility of this kind of request? Because it appears to be speculative at this point in time.
My Lord, that is well covered in a Nigerian case that is still cited in that decision, where the court went ahead to say that even if that such a prayer is not sought, the court said, read just one sentence, if it is necessary to do so, the court may even have to fashion new remedies to secure the protection and enforcement of these all important rights, so that you're not confined to the prayers that appear on the face of the application. You can fashion an appropriate remedy that protects the subject matter. And from paragraph 41, you see how the court navigated around that and came up with a remedy that was effective. And at paragraph 42, the court is saying Article 23 of the Constitution Article 23 provides that a court may grant appropriate relief when confronted with right violations. Under the same article, the applicant is entitled to appropriate relief, which means an effective remedy. For without effective remedies for breach or threatened breach, the values underlying the rights entrenched in the Constitution cannot properly be upheld or enhanced. My Lord, that is the same room you find yourself in. So fashion a remedy that does not allow escalation of these events, only later to learn that it was a false start. Throughout the submission by the respondents, you realize that there was no suggestion at all that the proceedings before the National Assembly were appropriate or were right. All what you were told, they may have a problem, but let it go to the end. Then we'll come and have a discussion about it. So let us right a wrong at the earliest opportunity that is presented before you. And that opportunity is this opportunity. The eventual outcome of this process boils down to the stability of the country. So public interest dictates that you prevent an absurdity and end when we have two deputy presidents. So kindly make a conservative order, even if it is not in the conventional conservative orders that are sought. Please fashion an appropriate remedy to prevent escalation of wrongs and to protect the stability of the country. I'm also going to thank you. Thank you.
Saying Mboro on behalf of the aid petitioner, I'm going to make submissions in respect to the respondent's submission. The first thing I start with is that you've been told that there was petition 550 of 2024 before Justice Gachagua, and you've been invited to disregard the consolidation that has been done this evening of 5 other matters that are now before you and which were not before that judge. And in that same light, you've been asked to treat the other 5 petitions as if they were before the judge and render that the same have already been determined. The second issue is that you have been invited to the submission that the prayers sought in the petitions are already overtaken by events. I invite the learned judges to look at our petition 528 and the order sought in that application, and indeed find that the orders are live and they have not been overtaken by events, as the orders seek to stop the Senate from acting on the impeachment motion of the Deputy President. That has not happened yet. So those orders are live and the court can grant the orders as claimed. You've been invited by counsel for the first respondent, that is Mr. Milimo, that the court ought to look or watch the violations. That is how I understood the submission. I mean, from the sidelines, and that no remedy can be formulated as the court is ought to exercise restraint in a matter as this one. However, if that were to be the case, I submit that that invitation should not be taken by this court, as that will completely undermine the supremacy of the Constitution. You have also been pointed out by counsel for the second respondent, Mr. Nyamondi, to a decision in Kiambu that has not been tabled before you, and that the pay of that decision cannot be taken to render or take away the right of determining the petitions that are before you, as that decision has not been submitted or supplied to the court. Therefore, that's a way the court should decline that invitation. The third respondent, Ms. Kanji, has indicated that the Senate is going to sit tomorrow. My submissions in respect to that is that the timeline indicated cannot out the jurisdiction of this honorable court. And where it is admitted by the Senate, as she has, that the Senate is not going to conduct public participation in complete violation of Article 118 of the Constitution, then the court should just sit and watch that violation go by. I submit, my lords and my lady, that upon such an admission, this court ought to grant the order as free, as the proceedings before the Senate will proceed before a very important aspect of public participation has been complied with.
Did I hear Ms. Naki make that admission?
She said that there's that Parliament, and I was actually coming to that point, my lord, that they consider the Parliament as one. That is the National Assembly and the Senate. And I wanted to refer this court to Article 193(1) of the Constitution that creates a distinction between the National Assembly and the Senate, therefore creating two levels, as opposed to the submission by Ms. Kanji that Parliament consists, that the public participation that was conducted by the National Assembly is sufficient. And for the benefit of the court, with your permission, my lord, I can read the provisions of Article 93(1), which provides that there is established a Parliament of Kenya, which shall consist of the National Assembly and the Senate. And the Constitution further goes ahead to create their different roles. Therefore, as per the provisions of Article 118, the requirement to facilitate public participation and involvement of to facilitate public participation in the legislative and other business of the Parliament is a mandatory constitutional provision, and they have admitted that there is no need to conduct that. Therefore, I do submit that a violation of the Constitution is imminent, that the proceedings that will take place tomorrow are proceedings that are not as per the provisions of the Constitution, and therefore this court is called upon to issue a conservatory orders to ensure that the supremacy of this Constitution is guaranteed. Lastly, with your permission, just 1 minute. When the court is called upon to interpret any right that is enshrined under the Bill of Rights, interpretation must be done in a manner that promotes or gives effect to the rights enshrined in the Constitution, rather than limit those rights. Therefore, when this court retires to make its determination, it should look at what gives effect to the rights that we have complained of being violated, rather than limiting those rights. Thank you very much for your time, for the question, and that is all.
Thank you. Yes. My Lord.
Who's next?
My Lord, on behalf of the 9th petitioner, I am Kubo. On behalf of Lempa, I would like to respond to the submissions of the respondents. My Lord, I'll be very specific. My distinguished learned senior, Ms. Tanji, quoted the doctrine of ripeness. She went ahead that
some things that you don't see. Put on your camera, please.
Yeah, sure.
My apologies, my lords. Ms. Tanji submitted on the doctrine of ripeness. She went ahead to inform the court that the petitioners are preempting what the Senate.
Please put on your camera.
My Lord, can you hear me? Can you see me now?
No, we can't see. Can you ask Lempa to proceed instead of yourself?
My Lord, can you be seen?
Who are you? Who are you?
We are in the office, my Lord.
Do you intend to submit before this court?
My Lord, I had appointed my assistant, Mr. Kubo, to give a rebuttal. And
yes, he's not able, we can't see him, and we don't know whether it is whom he purports to be.
I am the one who controls this laptop. I've probably now put the camera on for him. Kubo?
Apologies for that, my lords and my lady, for that technical.
Kubo, please dress yourself properly. Thank you.
My lord, my lady, I will go to the response that was given by Ms. Tanji on the issue of the doctrine of ripeness, where she alluded that the petitioners are preempting what the Senate will be, the role the Senate will play tomorrow, and the duties that the Senate will undertake tomorrow. My lords, my lady, the conservative orders sought by the petitioners are meant to allow this honorable court to investigate, interrogate, and prod the constitutional violations and infringements that have been cited in the 10 petitioners filed before you. My lords, my lady, it is our submission that this honorable court should interrogate those issues, those violations cited in the petitions, so that whatever transpires in the Senate is of hygiene. It is our submission that specifically issues around public participation, issues touching on what my distinguished learned senior Mr. Duita had alluded to, where the Speaker of the Senate, the Speaker of the National Assembly, and the Deputy Speaker of the National Assembly had pronounced themselves even before the motion dated the 26th of September 2024 was tabled in Parliament. My Lord, my ladies, we appreciate the role the Speaker plays in the National Assembly with respect to an impeachment on the Deputy President and the President. My Lord, my lady, it is incumbent upon this honorable court to make a finding whether the pronouncement by the Speaker before the motion was tabled had an adverse effect on the outcome in the National Assembly. My lords, my lady, as submitted by Mr. Twitter, those are weighty issues which, my lords, my lady, if they are left out in the air, they might land this country in a constitutional crisis. It is our submission that the violations that happened in the National Assembly have tainted the entire process. In that case, my lords, my lady, that process ought to be halted with immediate effect. There is no need to proceed to the Senate with a tainted process, a process that at the end of the day will be rendered unconstitutional. My lord, it is incumbent that this honorable court nips that issue in the bud. On my second issue, my lord, my distinguished learned senior Mr. Lempar had submitted that the honorable court orders that pending the hearing and the determination of the petition, a conservatory order issue restraining the president or his agents from nominating and or forwarding any name to the National Assembly for consideration of approval of a new deputy president. My lord, on that particular issue, I would like to refer to the question that Justice Murima had asked my distinguished learned friend, Mr. Duita, whether they had specifically prayed on that particular issue. My lord, I have a small confession that in our petition 525 of 2024, we had not made an explicit prayer with respect to that issue. But my lord, I will ride on Article 23 of the Constitution and the David Ndii versus the AG case, which, my lord, it gives this honorable court the latitude to even go ahead and tailor-make an order for the purposes of maintaining or rather conserving the subject matter of this issue. So, my lord and my lords and my lady, that is our humble rebuttal. Unless there is any other question from the court, we would like to rest our case there.
Thank you. Is there anybody who has been left out? Currently, nobody has been left out, and who can inform us when the Senate proceedings will start tomorrow? At what time?
They are starting at 9.
You never say they're shutting to start at 9 unless you stop them.
We have had you on the applications before the court. We shall consider them and render a ruling those applications on the 16th day of October in the open court at 8:30.
My lords, your leadership, permit me on behalf of the entire bar, those representing the applicants, respondents, to give a special appreciation and thanks to the bench. It's now after 9 a.m. Yeah. And the fact that this was created that time, sit very least long hours, it's something that we appreciate a lot. Thank you.
Thank you.